Hello, my dearest friends. Svetlana Shlapak, the founder of ukvisasuccess.com is here. If you are an international or a family member of an international, you are probably quite naturally concerned about your present and future rights to remain in the UK. I have been practicing UK immigration law for over a decade now and discovered that a lot of internationals and their family members have only a very vague idea about their immigration rights in the UK. And to rectify this, I decided to create this special frequently asked show where I'll be answering various questions and clarifying different aspects of EU law. If you find these videos useful, please do like them, subscribe to my channel and share them with those who may benefit from them. And here is your next question. EU nationals and their family members retain right of residence for children of EU nationals where an EU national has died or left the country. This is category number 2. Let me start by explaining the legal term retain right of residence. Basically, all rights of residence of family members of EU nationals are attached to EU nationals. And this means that if an EU national decides to go back to his or her country of origin, his or her family member will automatically lose his rights to remain in the UK and will have to leave the country together with that EU national person. That is unless this family member can claim that he or she has a retained right of residence in the UK. In my previous 2 videos, I've explained that there are 4 major categories of people who can claim that they have a retained right of residence. I've also given an example for the first category where an EU national family member has died. In today's video, I'll concentrate on the second category of family members who can claim that they have retained their right of residence in the UK. First of all, this category is not only about children, it also relates to grandchildren and great-grandchildren of the relevant EU nationals. They're called as descendants. As you have probably guessed already from the title of this video, there are 2 possible case scenarios. Number 1, where an EU national has died, and number 2, where an EU national has left the country. As with all other categories, you will need to meet certain requirements in order to succeed in the application and claim that you have a retained right of residence. Okay, what are these requirements? Number 1, you will need to prove that you are a direct descendant, a child, a grandchild, or a great-grandchild of an EU national who either died or left the country, or you are a direct descendant of a spouse or civil partner of the national who has died or left the country, and that that EU national was a qualified person and that he was either working, was self-employed, a student, or a self-sufficient person. And the third requirement, that you were attending an educational course in the UK immediately before the relevant EU national has died or left the country, and you continue to attend such a course. Remember, nursery is not included in the definition of an educational course, so the child will have to be either studying either primary or secondary school or university. And the child will lose his rights to remain in the UK as soon as he or she finishes her course. Let me give you an example. Let's say Pedro is a national of Portugal and he came to this country together with his non-EU national wife Anna and her daughter Melissa. Melissa is also a visa national because she is not Pedro's daughter, she is Anna's daughter from previous marriage. Melissa is 7 years old and she attends a primary school in the UK. After working in the UK for several years, Pedro decides to go back to Portugal. However, Anna doesn't want to leave the UK before Melissa finishes her education. So the question here is, will Melissa be allowed to remain in the UK on the basis of her retained right of residence? Okay, let us analyze this case scenario together. Does she satisfy the first requirement? Is she a direct descendant of an EU national? She is not, but she is a direct descendant of a spouse of an EU national, so this requirement is satisfied. The second requirement was the EU national in question a qualified person, and the answer is yes, because Pedro was working before leaving the UK. And the third requirement was the child, Melissa, attending an educational school in the UK, and the answer is yes. And will she continue doing so in the foreseeable future? And the answer is yes again. So if she makes an application for a retained right of residence, she is quite likely to be successful. However, if, for example, Melissa goes to the nursery, she attends nursery, then the application is unlikely to be successful because remember I told you that nursery is not included in the definition of an educational course. Due to Brexit situation and the uncertainty surrounding rights of EU nationals and their family members in the UK, permanent residence application forms topic became particularly relevant. I've noticed that some of you are completely lost in this 85-page form full of legal terms spread across the 19 sections. And therefore, I've created a free expert secrets guide on how to complete this permanent residence EEA PR form. And you can now claim your own free copy at bit.ly/free guide on EEA PR form. This offer is very limited though, so don't be left behind and claim your copy today. Please give thumbs up, subscribe, and share this information with those who may benefit from it. Thank you so much for watching and have a great day.